great honor and pleasure for me. Now, before I go into the subject, I would like to give you a brief introduction about myself, which would also because I have been seeing the chat box and quite a number of enthusiastic ADR participants. So I must say that when I started my career, I started off in the Calcutta office of Khetan and Company. I have been associated with this firm for close to 16 years now. And for 7 years, I worked in the Calcutta office of the firm. When I started my practice, I joined as a litigation practitioner, and of course, in 2008, when I passed out, arbitration was never given as primary treatment so far as mainstream dispute resolution was concerned. Now, is in arbitration over litigation, which is often a question I come across, and which I will be covering when we talk about arbitration. Essentially, what it means is that it's essentially it's supposed to be a non-adversarial form of dispute resolution before a private judge who has been chosen neutrally by the party. Now, that is very a layman understanding of it. Having said that, I must also put in a caveat that amongst the different forms of alternative dispute resolution mechanism, arbitration is basically a borderline adversarial form, already listed before the same court. And the time which you may get or the indulgence which you may get, unless it is the prefixed part heard matter, is very, very limited. And obviously, when there are 50 matters in the list, you cannot expect the judge to have the same level of attention span, one. Secondly, the meticulous approach by the judge. So that prompted me to arbitration, where a sole arbitrator or a three-member tribunal, which is typically the case, sole arbitrator or a third. So therefore, the level of arbitration, and if you ask someone, they would all say that if India has to become a hub of international arbitration, then institutional arbitration is the way to go. And as Varsha mentioned in the introduction, I'm associated with both BIAC and IIAC, and both are institutions, no difficulty, and I completely resonate the view that institutional arbitration is the way to go. But I also have a strong view about it, and which may not be in consonance with many arbitration practitioners. I would say that it has to be horses for courses. If you give it, then you're like the second judicial or your solicitor has to continue with the arguments. There are no excuses which are normally entertained. So these are things which are very, very, very significant when it comes to institutional arbitration. Now, why I say ad hoc arbitration is equally important. And if you talk about percentage, broadly speaking, 80 to 85% in India is all ad hoc arbitration. It's the basis for adopting and substituting, if I may say, the earlier provisions of the 1940 Arbitration Act when we came out with the 1996 Act. Now, by far, 1996 Act made a significant difference, particularly because the cost effectiveness, the cumbersome procedures, and third is reduced judicial interventions. These were the basic concepts which were fundamental to the UNCITRAL model law and which stood incorporated by way of the 1996 Act. The Arbitration and Conciliation Act is in and provide a comprehensive code and basically providing the entire process which is to be followed in the entire life cycle of an arbitration proceeding. The objective is to be fair, to be efficient and capable. Now, fairness is ensured, of course. There has been a lot of discussion and